Welcome, everyone. The Charles N. Brower Lecture was established in 2013 to recognize Charlie's preeminence in the field of international dispute resolution and his leadership in the society, of which he's both a prominent former president and a generous benefactor. Charlie, I can't see you here today, but I know you're with us. Thank you for everything that you do. The list of previous Brower lecturers is an illustrious one. Vivi Johnny Veeder, Sundaresh Menon, Michael Riesman, Gabrielle Kaufman-Kohler, David Karen, Meg Kinnear, Peter Tomka, and last year's lecturer, Daniel Bethlehem. Today, it's my privilege and true pleasure to welcome this year's lecturer, Lucy Reed, who served as president of the Society from 2008 to 2010. Lucy's career is remarkable, not just for its sheer breadth in terms of roles in academia, private practice, and government, cementing in my mind that she's up for any challenge, but also for her enduring commitment to the promotion of justice across the globe. Lucy joined Arbitration Chambers as an independent arbitrator in their New York launch in January 2020, as just the next chapter in her amazing 40-some-year international law career. From 2016 to 2019, she was director of the Center for International Law and professor of practice on the law faculty of the National University of Singapore. Prior to that, she was a leading light and leader of the international arbitration and public international law groups of Freshfields, based in New York, Hong Kong, and Singapore offices. Lucy currently serves as president of the prestigious International Council for Commercial Arbitration and is a member of the Council on Foreign Relations. She's also one of 2 vice presidents of the Singapore International Arbitration Center Court. As many of us well know, Lucy is very active as an arbitrator and served as a commissioner on the Eritrea Ethiopia Claims Commission, which was the first Geneva Convention International Humanitarian Law Tribunal, and as co-director of the Claims Resolution Tribunal for dormant accounts in Switzerland, the first Holocaust claims tribunal. Lucy's career has also included several years in high-level public service. While with the U.S. State Department from 1985 to 1993, she served as the U.S. agent to the Iran-United States Claims Tribunal and a lead advisor on international claims and investment disputes. Later, as the first general counsel of the international organization KEDO, the Korean Peninsula Energy Development Organization in New York, she led negotiations with North Korea. And always cognizant of a lawyer's commitment to public service, Lucy has focused her pro bono work on combating gender violence. I should add that not only has Lucy done it all to reach the pinnacles of our profession, but she's also an exceedingly generous person, a pathbreaker, and an incredible mentor to so many. Please help me welcome the 2021 Brower Lecturer, Lucy Reed. Lucy, over to you.
Thank you, Catherine. Am I on now?
You are.
Okay.
Good to have you here.
Thank you. Thank you, Catherine, for your too kind welcome. I want to congratulate you, actually, on your calm and inspirational leadership of the Society through these troubled times. And thank you all for attending this lecture in 2 dimensions. As has often been said, I really hope and trust that the next annual meeting in spring next year will see us together in person again. I have special thanks for Judge Charlie Brower. I hope you don't mind, Charlie, for my referring to you just as Charlie, as we all do, rather than Judge. Thank you for establishing this lecture series and for inviting me to be the 9th Brower Lecturer. I've been thinking about it, and I must have first met Charlie in the early 1980s at the Iran-US Claims Tribunal, where he was one of the first US judges, and I was a beginner lawyer at Wald, Harkrader, and Ross, representing US claimants. And I've been an admirer of Charlie in the 40 years since then. Charlie has always been generous and sometimes, shall we say, helpfully tough in his support for me, and I've learned a great deal from him. In addition to our work together with the Society, actually, Charlie opened the door to me, for me, to the Institute for Transnational Arbitration. This provided me with my earliest opportunities for speaking and publishing, and I eventually followed Charlie as chair. Charlie may not remember this one instance of his tough, or maybe I should say firm, guidance, which recently came back to me in discussions with my ASIL Willig mentorship group. When Charlie invited me to speak at an ITA workshop in Dallas in the early 1990s, I had just returned, let's just say with a very small savings account, to the United States from my time as US agent at the Iran-US Claims Tribunal. And Charlie explained to me patiently that I had to be an ITA member to participate as a speaker. And I recall thinking, really? I can't afford to pay the $300 membership dues, but I can't afford not to. Can I? Can't I? The end of the story is that I did pay the dues and I did speak. And Charlie, I consider it the best $300 I've ever invested in my career. So thank you again for that. Now, since then, as Daniel Bethlehem said last year, I have built up more scars of Charlie's arm twisting to be a patron of the Society. But like Daniel, I didn't much resist the arm twisting, and I consider these scars to be badges of honor. Now, let me turn to explaining my topic. As background, the title of Daniel's Brower lecture last year was The Greening of International Dispute Resolution, Stepping Back a Little. He described our being, and I quote, at a turning point in our shared calling in the pursuit of law, a just and effective law to govern our changing international society. Referencing Charles Reich's seminal 1970 book, The Greening of America, Daniel proposed that we take advantage of this turning point as an opportunity to review and refresh and rethink, not as repudiation, for the greening of international dispute resolution as we know it. His lecture ended with a possible agenda of change that he thought would merit discussion to get us beyond the leitmotif of the late 19th and early to mid 20th century dispute settlement being the preservation of peace and the avoidance of recourse to force. Daniel wanted us to move to a more variegated dispute settlement approach, in his words, with a sense of purpose that is properly in tune with a wider ambition. Now, Daniel went farther and he offered 8 possible issues for this agenda of change, including fresh thinking about the proper role and content of the principles of exhaustion of local remedies, denial of justice, and how better to address the reality of non-state actor participation in a refreshed IDS system. Now, lest one think that Brower lectures are filed and forgotten, Catherine's ASIL Strategic Initiatives Committee, which is chaired by Cal Rastiala, is exploring this very agenda now. Daniel tagged the 1899 and 1907 Hague Conventions on Pacific Settlement as being, and I quote, the standard bearers that still guide our way today, but from a different age. Now, rather than attempt an impossible revision of the conventions, Daniel proposed a strategic refresh, and he asked this question: why not explore whether a new, elegant text fit for the next 120 years can be crafted? It's not many steps from this question to the theme of this year's annual meeting, Reconceiving International Law, Creativity in Times of Crisis. Yet, I will be taking steps in the opposite direction with my lecture topic, which is crisis cases, not reconceiving international dispute resolution. The core proposition of my lecture is that there is a substantial but not well known except for a small group of people, a substantial body of experience and procedure for resolving international disputes arising in crises and post-crisis. Having had the privilege, as you heard from Catherine, of playing a role in several of these processes, I've learned firsthand the benefits of calling on that body of experience and the risks of attempting to conceive it anew. I've also learned that the proper, or maybe better said, the most useful role of international disputes lawyers and adjudicators is to serve when asked to do so, after defined disputes have arisen, or at least are on the clear horizon. Now, I've had occasion to return to these lessons with the unfolding of the current crisis, the COVID-19 pandemic. The specific prompt has been the increase in discussions about possible COVID-19 disputes and possible methods of resolving them, hence the focus of my lecture. Now, I know, I humbly know from my many years at this, that you will remember only a few things that I say today. So let them be these. First, there is little purpose, if any purpose, in setting up an international or domestic dispute resolution process to deal with disputes arising from a crisis, including a pandemic, unless there are resources firmly committed to pay, not just for the process, but to pay successful claimants or victims. Second, although, or maybe it's really because the disputes arising from any crisis are always novel, it's critical to use tested and trusted dispute resolution mechanisms as already basically conceived. There can be too much newness for stability. So I propose to start in the present with the pandemic. Anyone interested enough, and thank you for this, interested enough in international dispute resolution to listen to this lecture, I think could rattle off a list of possible COVID-19 disputes. And just to be clear, I'm not going to be talking now about the broader conflict crisis issue of the systemic injustice that's been brought about and revealed by the pandemic. It's a more modest approach to think of the kind of disputes that we deal with. And if you don't feel up to creating your own list, then just do a quick internet search. Trust me. You will find discussion of employment disputes, economic discrimination issues, business interruption, and other insurance claims, access to healthcare, other civil rights issues, and of course, a myriad of contract disputes. As for contracts, you will find a lot of old friends from your basic contracts class: the doctrines of impossibility, impracticability and frustration, force majeure, material adverse change, best efforts, mitigation, restitution. I could go on. On the internet, you will find discussion in law journal articles, blogs, webinars, conference panels. You will find authors and speakers from professional organizations like the ABA, law schools, and of course, law firms marketing for business. The blogs range from Law 360 to, this is real, to www.hollywoodreporter.com. Bloomberg Law ran a piece on the 11th of May, 2020 entitled Analysis, COVID-19 Litigation Pending, Poised to Boom. There are predictions that business interruption insurance claims may top $100 billion and that distressed investment funds and litigation funders may flock to finance and buy insurance claims to use to make money later. In January, the UK Supreme Court issued an advisory type judgment in favor of insurance policyholders. The title is Financial Conduct Authority v. Arch Insurance UK Limited and other insurers. In our field of international law, You will find discussion focused on human rights issues, including equal access to vaccines. Some address the prospects of suing China for violating the international law of infectious diseases to claim reparations for countries or individuals in mass tort claims. EJIL-Talk, that's the European Journal of International Law, EJIL-Talk ran an article on taking China to the International Court of Justice over COVID-19. And some ponder bringing investment treaty claims against governments based on unfair and unequal treatment, while others are already thinking ahead to the possible defenses of economic distress and necessity. Admittedly, and I know this as well as many of you, most pandemic-related dispute resolution webinars focus on the practical challenges, the nuts and bolts of virtual hearings, and the competing hopes and fears that international arbitration will never return to the three-dimensional world. Increasingly, though, there is discussion about substantive COVID-19 related claims in international arbitration and the potential benefits of exploring mass claims processes instead of a Bloomberg-speak boom of litigation. The most thoughtful piece I have found on the topic is a talk given by Constantine Partizaitis, QC, of Three Crowns, London, and that was on the 28th of May, 2020. It's only available so far as a recorded lecture on YouTube on a platform called Global Wonks. That's Global Wonks, not Global Works. Constantine tackles the question, and I quote, "How can the world of international dispute resolution make its contribution to the economic recovery that we must all work towards as the world emerges from the health crisis of the coronavirus?" End quote. The answer, in brief, is by providing quality, predictable, and efficient legal resolution of the inevitable disputes, but not in the traditional binary litigation model of plaintiff, defendant, claimant, respondent, winner, and loser. After noting that there was a small wave of contract litigation connected to the Spanish flu epidemic in the early 20th century, Constantine raises the prospect of a huge wave of COVID-19 lawsuits, particularly against insurers. And he posits that if, on the one hand, many claims are successful, we may see that we have an insurance industry collapse. But if, on the other hand, the claims fail, there will be devastation throughout various levels of the economy that will be even more far-reaching. He goes on to introduce less binary approaches that might minimize economic disruption. These include moratoria, such as the proposal by a group from the British Institute of International and Comparative Law for a breathing space, capital B, capital S, which would allow temporary relief from performance under legally viable contracts. And Constantine also briefly catalogs historic claims programs that have dealt with other extraordinary events in the past. And it is to history and some personal experience that I now turn. I could start in 1783 when Benjamin Franklin wrote, in one of my favorite quotes, "All wars are follies, very expensive and very mischievous ones. When will mankind be convinced of this and agree to settle their differences by arbitration?" But I will start again some 100 years later in 1872 with the Alabama Claims Arbitration. The late beloved Johnny Veeder colorfully recounted the history of the Alabama arbitration in the inaugural Brower lecture in 2013. The title of his lecture was "The Historical Keystone to International Arbitration, the party-appointed arbitrator from Miami to Geneva." As indicated by the title, his central focus was on the makeup of the Alabama Tribunal, as the first in modern times in which the disputing parties each appointed one arbitrator as a minority, thereby creating the model that we know as international arbitration today. And Johnny submitted, and I'm going to quote, The right of each party to appoint an arbitrator makes the arbitration the party's arbitration, deciding their dispute with their tribunal. And one reason users prefer arbitration over litigation is the sense of ownership by a party over the arbitral process. Now, most here at the Society will know the backgrounds of the case. Under the 1871 Treaty of Washington, Great Britain and the United States established a 5-person tribunal to arbitrate their legal dispute. Had Great Britain failed to meet its neutrality obligations by allowing the Alabama and other raider ships to be built in England and delivered to the Confederacy for warlike operations against the Union in the US Civil War. This was, you have to remember, in the wake of one armed conflict, the War of 1812, and facing the risk of another, that the United States and Great Britain turned to international arbitration. This party-appointed arbitrator procedure they followed might have been an innovation, but the basic structure of arbitration was long conceived. Again, wanting to ensure you that Brower lectures are not, I want to ensure that Brower lectures are not filed and forgotten. I urge you to read or reread Johnny's lecture. It captures him as the larger-than-life historian and storyteller that he was, with all of his characteristic intelligence and wit. I say this because he describes not only the conflicts underlying the raider dispute, but also the proxy conflicts that occurred to achieve the Treaty of Washington, to constitute the tribunal, and in the interactions between the cold-blooded Charles Francis Adams as the US appointed arbitrator and the warm-blooded Sir Alexander James Edmund Cockburn as the British appointed arbitrator. Somehow, though, they and their fellow at that time, arbitrators managed to resolve the neutrality dispute before them and issue an award of $15.5 million to the United States, which would be the equivalent of $225 billion today. Now, I think at this point you deserve a little screen break, so I will digress to add that Johnny was something of a student of Sir Alexander Cockburn, and he attempted to redress the balance to the extent possible, by which he meant impossible. He wanted to redress the balance of Cockburn's description by Gladstone's biographer as a natural, illiberal British chauvinist. Now, my favorite anecdote here in Johnny's lecture concerns a novel. So let me quote directly from Johnny's Brower lecture. Sir Alexander Cockburn had written a dark and morally troubled novel in his early days at the English bar. The novel was never published. It bears no title. It is never mentioned in any public account of his life. It is now to be found in 19 bound notebooks written in his own handwriting in the archives of the Middle Temple in London. The manuscript seems untouched, save for 1.5 readers over the last 150 years. The half reader, of course, was Johnny, and he admitted to his Brower lecture audience that he was unable to enlighten them on the full plot. Who was the departed Adele? Who was the blushing Félicie? Who was the mother of the baby son? Because Cockburn's handwriting became so increasingly bad that Johnny, had to stop reading somewhere around notebook number 9. Well, we'll leave that and we'll jump another century from 1872 to 1981 to the establishment of the Iran-US Claims Tribunal, arguably the most influential post-conflict international dispute resolution program. The tribunal as many know, followed the Iranian Revolution and hostage crisis of 1979. As structured in the Algiers Accords of 1981, the mandate of the tribunal was to resolve, among other disputes, contract breach and expropriation claims by US nationals against Iran. By the early 1990s, the tribunal had adjudicated the almost 1,000 large claims, those exceeded $250,000, filed by US businesses and individuals, and issued decisions that allowed the mass settlement of another almost 2,500 small claims. For purposes of this lecture, let me list 4 factors critical to the success of the tribunal. First, there were committed funds to pay successful US claimants. A security account was opened with $1 billion of Iranian funds previously frozen during the hostage crisis with a top-up mechanism. Second, the US Congress enacted legislation effectively forcing the removal of hundreds of lawsuits against Iran from the US courts to the tribunal. Third, the US and Iranian governments each appointed 3 judges of their own nationalities and together appointed 3 third country judges, thereby taking the type of ownership interest noted by Johnny in connection with the Alabama arbitration. Fourth, the tribunal adopted and modified the 1976 Untitled Rules, and in its published reasoned awards, developed the Untitled Rules jurisprudence that's so important today in investment treaty arbitration. Other mass claims programs followed the Iran Tribunal. One was the UN Compensation Commission, which was created by UN Resolution 687 following Iraq's illegal invasion and occupation of Kuwait in 1990. The UNCC processed 2.7 million claims using a largely statistics-driven claims process and ultimately awarded over $52 billion to some 1.5 million successful claimants. The source of funding was the UN Oil for Food program, which is a story for another day. Another successful initiative was the Commission for Real Property Claims of Displaced Persons and Refugees, established as part of the 1995 Dayton Peace Agreement between Bosnia, Croatia, and Serbia. The Real Property Commission issued over 300,000 decisions concerning property rights lost by civilians during the war in the former Yugoslavia. There have been several Holocaust claims tribunals. As Catherine mentioned, I was privileged to serve as a co-director and policy director of the Claims Resolution Tribunal for Dormant Accounts in Switzerland, called the CRT. The CRT was prompted in part by a lot of class action litigation in the United States brought by heirs of Holocaust victims and survivors seeking funds that had been trapped in secret Swiss bank accounts after World War II. The CRT was really a private initiative. On the one side, there was the World Jewish Restitution Organization and the World Jewish Congress, and on the other side, the Swiss Bankers Association. Together, they agreed arrangements to set up and fund an arbitration tribunal in Zurich in the late 1990s to collect and decide individual claims in the dormant accounts. Claims to the dormant accounts. The funds for awards came from the dormant bank accounts themselves, with interest added and replenishment by the Swiss banks for the bank charges that had been withdrawn over the decades. Upon completion of the arbitration part of that process in 2001, the CRT had rendered decisions in 9,918 cases and awarded approximately 65 million Swiss francs to claimants from more than 70 countries. The International Commission on Holocaust-era Insurance Claims was established in 1991, this time by European insurance companies, US insurance regulators, representatives of Jewish survivor organizations, and Israel, to compensate Holocaust survivors and their heirs and the families of non-survivors for claims under insurance policies that had been wrongfully canceled. This commission awarded over $300 million to some 48,000 claimants by 2007. Again prompted by a wave of US class action lawsuits, in July 2000, the German and US governments signed an agreement concerning something that was called the Foundation for Remembrance, Responsibility, and Future. The German parliament then passed legislation creating an agency to establish a compensation program for slave and forced laborers. One piece of this program was the German Forced Labor Compensation Program administered by the International Organization for Migration. The IOM processed more than 400,000 claims and paid compensation to over 90,000 slave and forced laborers and another 1,600 or so victims of other personal injury. One of the reasons, by the way, that the International Organization of Migration has played such a role in mass claims programs is the disruption that comes after a crisis or a conflict, which can lead to refugee flows and forced migration. Now, I could go on with more programs. There are a handful of other ones, but I will limit myself to just one more. The September 11th Victim Compensation Fund. And I picked this one because it illustrates the commercial and humanitarian purposes that can be met with a well-designed claims program following a crisis. The US government established the compensation fund following the World Trade Center attacks, both to compensate victims and to protect the aviation industry from claims that were threatening its collapse. In specific, the US Congress passed the Air Transportation Safety and System Stabilization Act, which allowed victims to opt either to go to the compensation fund with a claim or sue for tort in US courts. The act allocated funds, so taxpayer money, to the compensation fund to make payments, which is what likely led the vast majority of victims to opt for the compensation fund instead of court. Under the extremely experienced leadership of Kenneth Feinberg as the special master, the fund processed all the claims that were brought to it in under 3 years and distributed $7 billion to the survivors of approximately 2,800 persons who died on September 11th, and to another approximately 2,500 persons who were injured. Kenneth Feinberg has extraordinary experience, as I say. He played a key role in the aftermath of the BP oil spill and the Boston Marathon bombing, and most recently I read he's been named with his partner, Camille Biros, to administer the $500 million fund for families of those who died in the 2 Boeing 737 MAX crashes. So at this point in the lecture, I think it's worth my stepping back and contemplating aloud with you what made these claims programs successful. I'll highlight what I think are the 4 most critical factors. 1, defined disputes in need of resolution, experienced adjudicators and administrators. 3, solid rules of practice and solid rules of procedure and practice. And 4, funds, resources. In that order, first, there must be a need for legal dispute resolution. Not just a crisis, however important and hand-wringing. And I think I'm stepping back to the class I taught at the National University of Singapore to remember that John Collier and Von Lowe opened their book on the settlement of disputes in international law by noting that disputes have to be distinguished from conflicts, with the term dispute signifying, and I quote, a specific disagreement relating to questions of rights or interests in which the parties proceed by way of claims, counterclaims, denials, and so on, end quote. Second, there may not be many Kenneth Feinbergs in the world, but there are adjudicators and administrators with substantial experience in setting up, running, and closing mass claims programs. One, shall we say, older generation learned their skills at the Iran-US Claims Tribunal, with many going on to the UNCC, UN Compensation Commission, the IOM, and other programs. I should mention here that time and capacity of personnel is, as always, a factor. I flag the recent successful conciliation between Timor-Leste and Australia, which was the first compulsory conciliation under Annex 5 of the UN Convention on the Law of the Sea. In this process, Timor-Leste and Australia, following crisis after crisis, established a conciliation commission and ultimately managed to achieve a maritime boundary treaty. One key driver, and there were many, of course, and I followed this conciliation very closely in Singapore. One key driver was the dedication of the 5 commissioners who worked often full-time on the conciliation for over 2 years. Third, I cannot emphasize enough the importance of using existing and tested rules of procedure and practices, including the science of creating claims forms and collecting claims. Now, of course, the rules need to be adapted to the particular type of disputes spawned by the particular crisis, as happened with the UNCITRAL rules and the Iran-US Claims Tribunal. But reinventing or reconceiving the wheel can lead to unnecessary delay and even inequity. You might be thinking, why, when we're talking about crises and conflicts, do I emphasize procedure of all things? Well, the answer is that I found it so frustrating to the point of despair when I saw, after my experience at the Claims Resolution Tribunal for dormant Swiss bank accounts and other Holocaust claims programs were being set up, I found it so frustrating to see lawyers and others, always well-intentioned, writing rules from scratch, designing programs from scratch, and in the process, missing critical protections. Let me give you a concrete example. At the CRT, the claims forms, which had been published all around the world, mostly in media in order to find claimants, the claims forms did not have a field for date of birth or age. This made it very difficult to prioritize decisions for the claimants who were the most deserving of compensation and a sense of justice done, who were in their 80s and their 90s when the CRT was set up. And it's impossible to amend and send out new claims forms. I'll give you another example, which is a more positive one. For various reasons, the small claimants before the Iran-US Claims Tribunal, which were mostly small businesses and individual people who had lost everything when they had to leave Iran after the revolution, those small claimants ended up at the end of the queue for compensation. This was corrected in the practice of the UN Compensation Commission, which prioritized the very modest but urgent claims of the thousands and thousands of guest workers from many countries who had to flee Kuwait after the invasion. Now, perhaps I should have put money matters first rather than fourth in my list, because there's little point in setting up a claims program, however serious the relevant crisis and however deserving the potential pool of victims or claimants if there's no source of funds for the program and for compensation being awarded. I've given you some examples: the thawed Iranian funds for the Iran-US Claims Tribunal, oil for food for the UNCC, government sometimes, insurance companies, other companies in others. I haven't included here the Eritrea-Ethiopia Claims Commission, which Catherine mentioned, on which I sat as a commissioner. This commission was established in December 2000 as part of the peace agreement ending the then armed conflict between Ethiopia and Eritrea, with a mandate to arbitrate damage claims between the two governments brought on their own behalf or on behalf of their nationals, resulting from violations of international humanitarian law, including the Genevas, or other violations of international law. The Commission ultimately issued 25 reasoned awards and decisions, all of which are fully public and available on the website of the Permanent Court of Arbitration. And there is a lot to be said about the Eritrea-Ethiopia Claims Commission, but one thing is not about actual compensation. Neither of the two governments nor any other entity committed funds to satisfy awards. And to the best of my knowledge, the monetary awards issued by the Commission were never paid. So in sum, an international claims process will always need a universe of disputes, an institutional structure or organization, and funding. And as Johnny Veeder liked to do, I will quote Shakespeare as almost saying in As You Like It, that he who lacks money, means, and content is without three good friends in an international claims process. Now, it may not be Shakespeare, but there is excellent literature available to guide those contemplating a crisis-related claims process or multiple processes. Indispensable, in my view, is the IOM handbook edited by Dr. Norbert Wühler and Dr. Heike Niebergall. It's called Property Restitution and Compensation: Practices and Experiences of Claims Programs. I don't know if you can see this because I can't see who I'm talking to, but this is the cover of the book. It covers the legal framework, the organizational structure, the funding, the legal remedies, and the valuation methodologies of 10 different claims programs, some of which I've mentioned. Now I want to move a different direction and look at my subject from what has not worked. It may seem a roundabout route, but let me illustrate my answer with the early 20th century hopes that conciliation commissions would resolve international crises. Starting with a France-Switzerland treaty and the Locarno treaties in 1925, there were more than 200 bilateral conciliation treaties concluded by 1940. As described by Jean-Pierre Coq in the Max Planck Encyclopedia of Public International Law, this summa divisio between legal and political disputes was quite in fashion. And I think Professor Merrills it was who called it a vogue. But like all vogues, these permanent bilateral commissions did not lead to much. Only some 20 known cases over 90 years. In fact, it took 30 years for the France-Switzerland Commission set up under the 1925 treaty to have a dispute to resolve. So illustrating the wishful thinking about the power of conciliation to resolve interstate disputes, there is a raft of conciliation rules if you need them. These include the ICSID conciliation rules, which we know to be very formal, the UN Sixth Committee's model rules for the conciliation of disputes between states, the PCA optional conciliation rules, and the Asean Rules of conciliation. Yet there have only been, I think, 13 ICSID conciliations initiated and only one known, or only one reported to have been successful, the Tesoro. To the best of my knowledge, as with the conciliation treaties after, or in vogue, I should say, after World War I, there's been no reported use of the UN, PCA, or Asean conciliation rules. Similarly, parties have not used many arbitration rules in bodies that have been created with the best of intentions to use dispute resolution to serve different ends. The Jerusalem Arbitration Center, launched as a branch of the ICC in 2013 to resolve commercial disputes between businesses in Israel and Palestine, closed without ever having had a case filed. Prime Finance in The Hague provides an impressive roster of financial experts and a set of financial arbitration rules, but to the best of my knowledge, it has not attracted arbitration cases. And there are countless regional international arbitration centers that have never seen a single case because parties with disputes choose instead to contract for arbitration administered by long established and not newly conceived institutions. The real world of international dispute resolution, it would seem, is not one in which if you build it, they will come. Instead, if they come, we should build it on solid foundations of experience and practice rather than new concepts. Parties with live international disputes will find their way in crisis situations, maybe after a detour through national courts and class actions, but they'll find their way to international tribunals and commissions, not vice versa. And by saying this, I don't mean to be critical. It's understandable and admirable to want to use dispute resolution skills to work to tackle conflicts or crises, whether they're political, social, economic, environmental, but the task has to be more modest to resolve actual legal disputes that actually arise from crises. The tension here, I think, as I wrote this lecture, I realized the tension is really one of alignment, or more accurately, misalignment, which brought to mind to me the ideas developed by the late and beloved, again beloved, David Caron, in his 5th Brouwer lecture entitled The Multiple Functions of International Courts and the Singular Task of the Adjudicator. David focused on the challenges posed by the misalignment between the many functions of international courts and tribunals, which do properly include social functions, and the sole task of the adjudicator, which is to decide the disputes before her. When the social function of providing individuals with the means to resolve disputes with law is directly furthered by the judicial task of resolving disputes, then there's alignment between the social function and the judicial task. As an example of misalignment, David raised the creation of the Permanent Court of Arbitration by the 1899 Peace Conference as the manifestation of the feudal belief or hope that the international court, and that an international court would lead to avoidance of war. To illustrate, David referred to the 2002 order of the ICJ in Congo v. Rwanda. In the order, denying the request for provisional measures, which was for lack of a prima facie basis for jurisdiction, the court recorded, and I quote, "It was deeply concerned by the deplorable human tragedy, loss of life, and enormous suffering resulting from the continued fighting," end quote. Judge Bergenthal objected to this and similar paragraphs, not because of the proposition, but because the court's responsibilities in the maintenance of peace and security under the charter, in his words, are not general, but strictly limited to the exercise of its judicial functions in cases over which it has jurisdiction. In David's premise, the indirect social function of maintaining peace and security is not the court's direct judicial task. So walking us back from armed conflict crises to the crisis with which I started, the COVID-19 pandemic, I submit that we need to ask ourselves a litany of hard questions about the proper adjudicatory task of international dispute resolution. To list just a few of such possible questions: what exactly are the international disputes that need resolving? State responsibility for personal and economic injury, business interruption insurance claims, commercial contract claims, with all these categories, exactly what type? For viable categories of disputes, what institutional structures might work? An arbitration tribunal, a computerized mass claims program, a conciliation commission? What rules of procedure and practice fit those disputes and structures with what necessary modifications? And absolutely critically, are there funds for the process and the payouts? Now, the natural first stop here would be governments, but they've already invested literally trillions of dollars in economic relief and stimulus plans. One might look to the winners in this pandemic. For example, technology companies like Zoom, Google, Apple, Amazon, FedEx, DHL, and UPS, Pfizer and Moderna. But then again, those that have benefited from the situation have also sacrificed by working on the front lines. How much can philanthropy actually do? I can't say I'm sorry that I have answers. What I can say is that I'm glad the hard conversations have started. I don't know whether we'll see a boom in COVID-19 litigation and then perceive a realistic role for funded international claims processes. What I do know, and I know this from so much experience in claims programs, is that if we do see a role for claims processes, there is guidance and wisdom to call upon. To conclude, I repeat that however serious the relevant crisis and however worthy the potential claimant pool, international dispute resolution mechanisms should not be set up unless called for by stakeholders who can identify actual legal disputes. However expert our dispute resolution skills may be, we should not be conceiving what we think potential parties need or want or should want. When, or if and when, there is a concrete need for international dispute resolution in connection with a crisis, this pandemic or another crisis, that is exactly the time not to reconceive the basic mechanisms available. So thank you again, Charlie and Catherine and all. I look forward to our post-pandemic crisis meeting next year to hear the 10th Brower Lecture. With that, I conclude.
Lucy, thank you so much. How thoughtful that was. And in some sense, you took Ben Franklin's Shakespeare, a historical treatment, to ask some very hard questions that are right along our theme. And in some instances, I think, as you say, is reconceiving international law really an opportunity to stick to what works and has worked while asking some basic questions about alignment of goals and structures. And you almost gave us a roadmap, frankly, of how to think about this historical practice and the relevance to COVID-19 today. It struck me as, and we're going to be populating with some questions, and there's also the continue the conversation opportunity, which you've so kindly agreed to participate in. But let me use the moderator's prerogative. But in going through these various, whether it's Alabama, the Iran claims, the UNCC, the CRT, et cetera, those are certainly instances where you have conflicts or you have crises and that implicate either bilateral or multilateral issues between states. And they're is the basic question of the political will of how to manifest that resolution, whether it's an Iran claims tribunal or it's something a bit less formal, but gets you to a claim commission process. Here, rather than a bilateral regional, we have this truly global scope. And the question of political will in that very fundamental respect, how do you think about something as diffuse and comprehensive as what COVID-19 has wrought? And is that an aspect of those very diligent questions that you laid out? Are these just national conversations that countries have domestically in terms of compensation, or is there an international component? How do you think about COVID-19 and perhaps some of its uniqueness as a crisis?
Well, that's a very hard question, and I think going back to the peace conferences and what didn't happen to avoid world wars, and what the UN has and has not been able to do, I would not be optimistic about seeing the WHO or the UN or some other international movement to equitably and fairly deal with the fallout from COVID-19. Hence, I think it will have to be nationally funded programs for relief for the human damage and the business damage. I hope it came across in my lecture that what I really hope we don't see is a huge tsunami of claims in court with the only resources available to satisfy them ruining whole industries. And of course, we've seen the competition for the vaccines, and right, all you have to do is look at the newspapers and see India's not sending, the EU's not sending. It's quite something, and it takes diplomacy. I hope to see more from the WHO in terms of guidance. And I think, by the way, what prompted my whole lecture was having a deja vu with the Holocaust tribunals. I offered my services for free many times over to say, please don't write another set of rules. Please don't try to come up with another structure for a limited claims program, because I learned the hard way in different programs. But no, everyone's got to do it himself or herself. And I would like not to see that happen with the subsections of categories of overlapping claims with a pandemic.
Yeah. Well, you certainly made a very persuasive case as to why that shouldn't happen. One follow-on question to that, because again, as you noted, there are some long-standing conciliation rules, for example, by very experienced institutions, including ICSID. And as you pointed out, there's been relatively little uptake. I myself have wondered why that is. What do you think about that? Why do you think there's been relatively little uptake of formal conciliation, those kinds of rules?
The main reason is that governments are very complicated entities that find it hard to settle voluntarily. It can range from individuals not wanting to take responsibility for a settlement, particularly one that's going to lead to some sort of payment, worries about political futures. And I've had experience with conciliations of my own where if a state entity does want to settle a dispute, there are worries about charges of corruption, that they will have taken a payment in order to come to a settlement. There are a lot of really good efforts underway right now, including with the Institute for International Mediation, IMI, and ICSID and UNCITRAL, and of course with the Singapore Convention on trying to push more conciliation. It's what I was teaching at NUS, and I'm trying to do more of that actually, Catherine, than arbitration, because I think it's more productive. But as you said in your first question, there are lots of disputes between states that are not going to be settleable. There's just no middle ground.
Thank you, Lucy. Let me go to a question we got. I'll just read it out. Lucy, you cautioned against creating new systems from scratch for fear of missing critical protections. But is there a risk of repeating the same approaches over and over and not pursuing new methods of dispute resolution without the chance to build something entirely new?
It's a good question, of course. And what I was trying to get across is every crisis will be unique. And so the types of claims will be unique and the types of remedies will be unique. And it requires a lot of creativity of necessity. My plea is not to try to redo the basics as well. That it's not just one system. The Iran Tribunal was one way. It was always a claimant and a respondent. The UNCC was more whole groups of claims with statistical sampling. They're all different, but the basic building tools don't need to be created because a lot of time is wasted while people are waiting for compensation.
Understood.
So there's, yeah, lots of creativity, but not in the basics is my plea.
It's a fine balance, but a very good one to hit. Well, thank you so much. We've run the clock. Everyone, please, if you'd like to continue the conversation, you have that button. And then finally, let me just say thank you, Lucy. It's a brilliant lecture and continues the very, very fine tradition of the Brower Lecture of tackling the hardest issues with the best minds. So thank you so much for everything that you have shared with us today. And everyone else, we are going into our final stages of the annual meeting. I hope you will join at 4 p.m. where we will raise our glasses. And of course, there is a cocktail recipe and a Shirley Temple version for everyone to make their own. So please do join us. We'll love to close it out with you. Lucy, see you soon.
Thanks, Catherine. Bye all.